The story so far, we talked about all of this. California got on Tesla's case because they said Autopilot and FSD was misleading. They said you've got until February 14th to change it, or you lose your dealer license. So they did, and now new cars do not come with Autopilot, and you can only get FSD by subscription. They had until the 14th to appeal. They didn't, so I was figuring my reporting was that's that. That they must have figured that this was just easier to comply with than fight. But no, turns out they were fighting an entirely different way. They just dropped this lawsuit in Superior Court of California. They just sued the crap out of the DMV. So since I've been covering it, I thought I'd go over this document. It's a 50-pager. We won't be going over all 50 pages. In Superior Court of the State of California, a verified petition for a writ of mandamus and complaint for declaratory and injunctive relief. Let's get into it. Page 1 of the complaint, which is page 3 of the PDF. As usual, I will be reading out the PDF page numbers. That makes it easier for you to follow along. Tesla brings this case to reverse a DMV order that wrongfully and baselessly labels Tesla a false advertiser for marketing its industry-leading advanced driver assistance systems under the brand names Autopilot and Full Self-Driving Capability. The DMV order is deeply flawed. In a case purportedly about consumer confusion, DMV presented no customer witnesses and instead relied almost entirely on the testimony of a single law professor. The order attempts an end run around this lack of evidence by ignoring the relevant legal standard and unlawfully shifting the burden of proof onto Tesla. And the order disregards a critical fact that should have been dispositive. It was impossible to buy a Tesla equipped with either Autopilot or Full Self-Driving Capability, or to use any of their associated features without seeing clear and repeated statements that they do not make the vehicle autonomous. The order is factually wrong, legally flawed, unconstitutional, and should be set aside. And it's even fattening, I guess. It's everything. It's all the bad things. Now, this is the first time any court has heard anything about this. This is one of those things we've talked about administrative law. The California DMV is not a judicial organization. They're under the executive branch. That means they execute the laws, but they do have the capability to do an administrative hearing or whatever. Basically, they set themselves up as judge and jury. We talked about a lot of that when we covered the Chevron doctrine, which the Supreme Court overturned for federal departments, although they can still do it to a degree, but that didn't have anything to do with states. States can still pull all this crap that they want. But in order to do this under the law, under California state law, they have to prove that either the challenged terms were legally false or that a significant portion of reasonable consumers could be misled by the challenged phrases in the relevant context. The DMV itself concluded that the term Autopilot is not actually unambiguously false or counterfactual. And the order's conclusion that the term Full Self-Driving Capability was actually false was contrary to the evidence presented. Despite the absence of literal falsity, DMV did not hear testimony from a single consumer. It admitted no evidence to establish that the challenged statements have caused actual confusion to any person, and disregarded evidence showing that people were not confused. And DMV ignored that it was impossible to buy or use a Tesla equipped with either Autopilot or Full Self-Driving without being informed that they do not make the vehicle autonomous. Instead, DMV relied almost entirely on the ipse dixit of a law professor masquerading as an expert who admitted that, contrary to the law, he had not considered the context in which the terms were used. That flimsy record falls far short of satisfying DMV's burden. Basically, they're just making up their own law and then setting themselves up as the judge and jury. The order violates the First Amendment to the Constitution and Article 1, Section 2 of the California Constitution. Tesla's label Autopilot is commercial speech that enjoys First Amendment protection as long as it is not inherently or actually misleading. DMV's order flouts that principle. Instead, it concludes the term Autopilot was misleading and therefore threatens to suspend Tesla's dealer license by ignoring the context in which the label Autopilot appears. context that, again, renders it impossible for that term to mislead anyone. That cannot survive scrutiny. Finally, DMV's procedure deprived Tesla of its constitutionally protected due process rights. After serving as investigator, charging party, and complainant, DMV then served as the final decision maker after adopting a recommendation arising out of proceedings rife with procedural and legal errors, notably including the administrative law judge failing to follow her own pre-announced rules. They get to make up the rules, and then they get to ignore them. The entire process was grossly unfair and violated Tesla's 14th Amendment right to due process. So they go over all the jurisdiction and venue and the parties and screenshots where it says, please pay attention, please keep your hands on the wheel, all that sort of stuff. Let's go over to page 14 where we talk about DMV's investigation and accusations. DMV began investigating Tesla in 2017. Their investigator, Melanie Rosario, from their investigations division, concluded that same year that the label Autopilot was misleading. Over the ensuing years, and she just did that. She just decided it on her own. Ms. Rosario continued to issue multiple investigative reports regarding the labels Autopilot and FSD and statements on Tesla's website. DMV did not initiate any enforcement action against Tesla for 5 years. During that time, contrary to her standard practice, Ms. Rosario never communicated these findings to Tesla or otherwise informed Tesla DMV believed the terms Autopilot or FSD were misleading. So I guess the only place that exists is in her own mind. She doesn't even tell anyone about it. It's so misleading, customers are being misled, yet she's just going to sit on it for 5 years and not even mention it. DMV initiated the current enforcement action on July 28, 2022. Resulting proceedings required OAH to conduct a formal administrative hearing before ALJ, pursuant to Chapter 5. DMV then sat on its hands while the matter remained dormant before OAH for another 16 months before DMV eventually filed its currently operative first amended accusations about 4 allegedly misleading statements, the labels Autopilot and FSD, and 2 statements from the Future of Driving webpage. According to DMV, these 4 statements were false, misleading, and deceptive because they allegedly represent that vehicles equipped with those ADAS features will operate as an autonomous vehicle. They held a 5-day hearing on DMV's allegations from July 21st through 25th, 2025. They only called 2 witnesses, Ms. Rosario and a purported expert witness, law professor Bryant Walker Smith. Tellingly, in a consumer fraud case, DMV did not present any consumers at trial. They didn't bring forth a single person to say they were misled. Not one. Ms. Rosario attached screenshots of Tesla's website. She reviewed the screenshots and concluded based on her own personal judgment that Autopilot was misleading. She acknowledged that numerous disclosures appeared on Tesla's website and in its vehicles that undercut her conclusion, but she consciously decided to ignore those disclosures. She testified that she never spoke to any consumers or conducted any research as to how consumers viewed the challenge labels and statements. Instead, in her final investigative report published June 2025, shortly before the hearing, Ms. Rosario attached 9 communications regarding Tesla's vehicles received by the California Department of Justice and DMV, as well as civil lawsuits filed against Tesla. Yeah, other people are suing Tesla, so we're just going to grab their statements and pull them in here. Ms. Rosario did not interview anyone or otherwise conduct any inquiry to confirm the truth of any of the allegations in those documents, including whether any of the referenced consumers actually ever owned a Tesla or whether their allegations related to or supported DMV's accusations. Moreover, she conceded that not one customer in those complaints suggested they had been misled. Even the ones who were suing Tesla never claimed to be misled. In fact, those that mentioned anything relevant to this case stated that Tesla told customers its vehicles were not autonomous. Rather than supporting DMV's case, the communications instead confirm that the individuals who purportedly sent them were not confused. One explicitly noted that drivers are aware that they need to pay attention and be ready to intervene when needed. Another explicitly recognized that Tesla's advertising relates to future autonomy with current hardware and future software updates. It's a promise that one day they'll be able to make it fully autonomous. Just not today. DMV also presented Bryant Walker Smith, professor of law at the University of South Carolina, and a member of the On-Road Automated Driving Standards Committee of SAE International. Those were the ones that made that little 5-level thing when they talk about level 2 autonomy, level 3 autonomy, level 5, which I've said before is actually completely useless because it doesn't actually tell you the things you need to know. Because both an active cruise control and FSD are all lumped in as level 2. Even though they're as different as night and day, they're completely different categories. Smith was belatedly and improperly disclosed. The ALJ ordered the parties to disclose experts, along with a short statement regarding the topics of their testimony, by June 25th. DMV ignored these rules and instead disclosed them on July 7th, purportedly as a rebuttal expert to Tesla's witnesses. Notably, although the ALJ's pretrial order did not permit rebuttal witnesses, the ALJ decided to allow the designation of Smith, subject to disclosure of his expected testimony as was required for all experts. DMV failed to provide that required disclosure. Notwithstanding the supposedly limited rebuttal scope of Smith's testimony, Smith's actual testimony, offered over Tesla's motion in limine and repeated objections, covered numerous areas that DMV did not disclose, for which he was not qualified and which did not rebut any Tesla expert. Smith admitted that he was not a linguist or expert in consumer behavior or marketing. Smith also admitted that he did not consult any materials to inform his opinions as to the meaning of Autopilot, not even Tesla's website, which he considered irrelevant, and thus he did not consider the feature name in its full context. When shown Tesla's website at the hearing, Smith admitted that the disclosures contradict his assumption as to the meaning of Autopilot. In fact, the only document Smith consulted was a document he helped create, the SAE Levels of Driving Automation Chart, a technical industry document that does not prohibit terms such as autopilot or self-driving. Smith further admitted that he never spoke to any Tesla consumers or prospective consumers in connection with his expert testimony to understand how a prospective or actual customer might view the challenge statements. Nonetheless, he offered his personal view of the word autopilot and speculated as to its impact on consumers. And this is a point I've made. Autopilot, of course, comes from the aviation industry, and no one thinks that just because an airplane is on autopilot, that the pilot can play on his phone or sleep or whatever. He has to supervise the plane while it's on autopilot. So he testified that in his personal opinion, while any pilot knows that autopilot in airplanes does not replace a human pilot, ordinary drivers do not understand this point and may believe that the expression being on autopilot might mostly mean that they've zoned out mentally. You see, you're too stupid. Not like him, who's an expert. Not like your wonderful ruling class in the government. You're stupid. So when you see a word, you don't know what it means. And in your stupidity, you might be misled. Do you see how these people think about you? And we see this attitude over and over and over again. And it's absolutely disgusting. Smith confirmed that the phrase self-driving has not been limited to autonomous vehicles and commonly means something less than autonomous. Nevertheless, Smith testified to the bald legal conclusion that this term was supposedly beyond misleading to consumers, despite having failed to speak to a single Tesla consumer or prospective consumer. He doesn't need to, because his imaginations of how dumb you are correct. All he has to do is think it, and it's right. Despite having admitted that he was not a linguist, Smith testified that adding the word full made the phrase more misleading than merely self-driving because full functioned as an amplifier. Smith further testified that in his view, the word capability in the feature name denoted a present ability, so he doesn't know what words mean. DMV introduced no evidence, direct, indirect, or otherwise, that Tesla's ADAS packages are unsafe. Tesla attempted to introduce evidence of the safety record associated with its ADAS packages, but the evidence was excluded over Tesla's objections. And they just released some updated statistics on that, and it's something like you would have to drive over the circumference of the Earth over 200,000 times before you would need to intervene with the latest version of FSD. But who cares? Despite having no burden whatsoever, and certainly no burden to disprove DMV's case as the ALJ purported to require, yep, they're gonna shift the burden of proof here. If the government comes after you, they have to prove their case. They can't just say it and then you have to disprove it. But that's exactly what happened here. Tesla introduced evidence of the capabilities of its ADAS packages and the context in which a consumer would learn about these systems. This evidence included testimony of its engineers, the actual advertising at issue, disclosures that made clear that, for every Tesla model sold, neither Autopilot nor FSD made Tesla vehicles autonomous at the time of purchase, owner's manuals and other Tesla web pages making the same point, and evidence regarding the actual operation of the features in the vehicle that ensure drivers understand they currently require active supervision. Critically, Tesla's evidence showed that it was impossible to purchase a Tesla or to use FSD or Autopilot without viewing multiple disclosures confirming that they weren't autonomous. Drivers must have activated FSD and Autopilot every time they wanted to use those features. Activation was accompanied by disclosures that the driver must be prepared to take over. Tesla also presented two expert witnesses to explain how consumers understand the relevant phrases. First is Dr. Sandra Disner, professor of linguistics at the University of Southern California. She's a linguist. She knows what she's talking about. She knows what you're talking about because she's a linguist. She knows the meanings of the words you say. She testified as to the meaning of Autopilot, FSD, and the challenge statements. For example, analyzing the etymology of the word Autopilot and consulting various dictionaries, she testified that consumers unequivocally understood Autopilot to be an assistive technology that requires active supervision and does not mean that a vehicle is autonomous. Tesla also presented Dr. Stephen Knowles to testify at the hearing. I'm not sure if I'm pronouncing that right, but he's a professor of marketing, so he knows all the marketing stuff too. And he knows how consumers are going to respond to marketing and what they're going to think about it. Dr. Knowles provided the only consumer survey analysis in the case and found no evidence that consumers were misled. The only consumer survey said they weren't misled, and they didn't put on a single consumer to say they were. The ALJ's proposed decision was not shared with Tesla. They sat on it, remember? Instead, Tesla learned from the press, not from the ALJ, not from DMV, and not from DMV's lawyers, that the ALJ had issued a proposed decision on or about November 20th, 2025. Thus, while the ALJ shared her recommendation with the director of the DMV, it was shrouded in secrecy, and Tesla was not allowed to know the content of the recommendation for nearly an entire month. So on top of everything else, they're behaving like a secret court. Orwell, meet Kafka. Tesla attempted to speak with DMV during the secrecy period, but DMV refused to engage in any discussions despite an intervening Ninth Circuit decision that was inconsistent with DMV's position. On December 16th, DMV, the same agency that initiated the action, simultaneously published the ALJ's recommendation and adopted it, subject to a reduction or mitigation of the proposed penalty. And here are the ALJ's facts. The ALJ discredited the consumer and civil complaints that DMV had offered as evidence because the examples are hearsay and therefore inadequate to show that any reasonable person actually misunderstood respondents' vehicle's functions, which should have been the end of it. But no, they credited as persuasive the testimony of DMV's law professor expert, Smith, that he believes the word autopilot to be potentially misleading because it suggests the human might have zoned out mentally. I think he zoned out mentally. The ALJ similarly credited as persuasive Smith's statement that he believes the name FSD to be beyond misleading, whatever that means. The ALJ did not once mention or purport to rely on Ms. Rosario's testimony or the statement of a single consumer. Instead, the recommended decision leaned heavily on Smith's testimony, which was riddled with both substantive and procedural errors. The only other basis for the decision was the ALJ's personal observations and opinions, neither of which is competent evidence. So now the judge is being a witness. The ALJ discounted the testimony of Tesla's expert regarding the term autopilot. She found Dr. Disner's testimony about the history of the word unpersuasive because one of her sources was an unattributed YouTube video. Her testimony on the current meaning of the word autopilot was unpersuasive because she disregarded in her analysis a secondary definition of autopilot because that definition was metaphorical. Disregarded uses that equated autopilot with unconscious action and did not give any special attention to how other automotive manufacturers or dealers or people writing about motor vehicles either as professional journalists or as amateur enthusiasts use the word. None of that's relevant anyway. What did consumers understand it to mean? That's important. The ALJ then considered the opinion of Tesla's expert Dr. Knowles. They found his survey data persuasive and the resulting conclusion that the terms autopilot and full self-driving in these web pages' context do not increase the likelihood that readers will believe respondents' vehicles to be autonomous. She stated that the survey did not assess how any reasonable person might interpret either name in a different context, such as without having seen any of the web pages, that it wasn't conducted during the relevant time periods, didn't compare respondents' feature names against any real names that other automakers use, didn't ask to identify specific behaviors they believed would constitute active driver suspension or driver readiness, and did not assess comprehension among people who did not have an interest in buying a Tesla. Finally, the ALJ concluded that no evidence from the hearing addresses whether the feature names and marketing statements at issue in this matter, if false or misleading, have caused actual confusion or financial harm to any person. Notably, these findings were not based on any statements or testimony by a single consumer from among millions of Tesla shoppers and owners. She concluded the Autopilot name, as respondent has used and still uses it to describe respondent's vehicle's standard ADAS feature set, is not actually unambiguously false or counterfactual, which again should be the end of it. Nonetheless, she determined that the term is misleading based on Smith's belief that the term was potentially misleading as corroborated by the complaints that she herself had referred to as inadequate hearsay. She disregarded Dr. Knowles' contrary testimony because she found that it does not disprove complainant's allegation regarding the potentially misleading nature of the Autopilot name. Yeah, they don't have to prove it. You have to disprove it. You have to prove that you did nothing wrong. The ALJ further rejected Tesla's evidence, noted that DMV's allegation is the name itself, which respondents chose, is inherently misleading. She did not explain how that allegation could be reconciled with her own conclusion that the term is not actually unambiguously false or counterfactual. As with Autopilot, she disregarded Dr. Knowles' contrary testimony because his study does not disprove complainant's allegation regarding the potentially misleading nature of the FSD name. She similarly declared that context surrounding the term could not defeat her conclusion. It's just her conclusion. She's not going to let any facts get in the way of it. In support, she relied on a single statement taken out of context from Tesla's expert, Dr. Disner, that the statements might mislead someone under circumstances not present here. Yeah, if they had done things completely differently, it might have been misleading. The ALJ thus determined that the web page could mislead a reasonable consumer and thus violated the vehicle code. Then they go into the penalties, the order, how Tesla exhausted all the administrative remedies. We're getting out of their cause of action. This is on page 28. Abuse of discretion is established if the respondent has not proceeded in the manner required by law, the order or decision is not supported by the findings, or the findings are not supported by the evidence. DMV's order is a prejudicial abuse of discretion multiple times over. Specifically, the order's findings are not supported by the record. Tesla did not receive a fair administrative hearing, and DMV did not proceed in the manner required by law. The record doesn't justify their conclusions. Their findings that the challenge statements are misleading were not only wholly unsupported by the evidence, but contrary to it. They relied on less than wafer-thin evidence that does not establish the conclusions DMV reached. They found Autopilot was misleading without any basis in the record. The order itself forecloses that conclusion because it admitted that the term Autopilot is not actually unambiguously false or counterfactual. The record also fails to support any finding that the term Autopilot could mislead any reasonable consumers, let alone a significant portion of them, as the applicable legal standard requires DMV to prove. The order pointed to unsubstantiated consumer complaints that the order itself admitted are hearsay and inadequate. The law required DMV to prove that the term could deceive a significant portion of reasonable consumers. Moreover, Smith, who is not a linguist or marketing expert, conceded that he never reviewed the Tesla website in which the advertising itself appeared, never spoke with consumers, and never conducted any other research about how consumers understand the term Autopilot. He just assumed that they were stupid, that they didn't know what it means, and that they would misinterpret it the way he says they would. Smith's testimony was inadmissible because it addressed the ultimate conclusion in the case, whether the challenge term is misleading. Expert witnesses are not allowed to testify to legal conclusions in the guise of expert opinion, and therefore such legal conclusions do not constitute substantial evidence. Experts are not there to reach conclusions. They are there to give testimony about things that require the expertise. The legal conclusions are for the judge or the jury or whoever the fact finder is. The expert will say the DNA found on the knife matches the defendant. He will not say the defendant did the murder. You can't make that conclusion even as an expert. You're just submitting facts. In short, the only evidence in support of DMV's findings is unsubstantiated hearsay and the inadmissible ipse dixit of a single law professor that do not meet the standard to find a challenge statement unlawfully misleading. The record is devoid of any other evidence. No consumer witnesses, no surveys, no tests, nothing demonstrating that these statements were in fact misleading to consumers at all. Despite taking more than 5 years to prepare its case, DMV presented no testimony from a single consumer who had been misled by the word Autopilot, let alone evidence of a single consumer who had been harmed by the word Autopilot. The order admitted that there is no evidence that even a single consumer was confused or harmed. The burden was on the DMV to prove that all the challenge terms are misleading. DMV's complete failure to introduce competent evidence to meet that burden is more than enough to overturn the order as an abuse of discretion. The order ignored that DMV's own expert conceded that the term Autopilot was accurate or at most ambiguous as opposed to literally false. The order arbitrarily rejected the testimony of linguistic expert Dr. Disner in toto. The order also erroneously rejected the only survey on the record regarding consumers' understanding of the challenge terms, Dr. Nolis's survey data, because it did not assess how any reasonable person might interpret either Autopilot or FSD in a different context, such as without having seen any of the 3 web pages. But the reasonable person does not view the product in an unreasonable manner, such as by ignoring context. And the undisputed evidence in the record was that a consumer could not buy a Tesla without having visited the web pages that Dr. Nolis tested. The ALJ noted that the survey was limited because it did not consider people who were not interested in buying a Tesla. But this is again incorrect. The reasonable person standard asks whether a reasonable consumer would be misled during the ordinary purchase and use of the product. People who aren't buying Teslas and aren't interested in buying Teslas are irrelevant to this. If you don't see the marketing, you're not misled. To the contrary, the record reflects that a reasonable person could not possibly have been misled by the term full self-driving capability, given the same explanations that accompanied the sale and use of all Tesla vehicles discussed above. The order wrongfully disregarded the only consumer survey evidence in this case regarding the meaning of this term and establishing that it is not misleading. The order wrongfully placed the burden on Tesla to show that a reasonable consumer could not be misled, as opposed to requiring DMV to show that the reasonable person could be misled. That's a complete flip of burden of proof. The order failed to apply or even state the correct legal standard for determining whether the names Autopilot or FSD are misleading. The order determined that Tesla's challenge statements were misleading by repeatedly refusing to consider surrounding context that rendered those terms not misleading. That was legal error. The law is clear that a reasonable person considers context when buying a product. This error was again significantly prejudicial to Tesla because, upon review of context, it is clear that no reasonable consumer could have been misled. This order violates the First Amendment and Article 1, Section 2 of the California Constitution. And let's skip over to page 38. Tesla did not receive a fair administrative hearing. Instead, the proceedings below were patently unfair and were a denial of Tesla's due process rights. DMV internally concluded that Tesla's use of the labels Autopilot and FSD and the statements on their website were misleading years before bringing the instant lawsuit, and internally issued multiple investigative reports to that effect. They started with a conclusion, and everything else is arguing from it. Breaking from standard practice, they decided not to inform Tesla that DMV had concluded that its labels were misleading. The ALJ overseeing the matter then repeatedly made procedural errors that seriously disadvantaged Tesla. As one example, the ALJ allowed evidence from expert witness Smith despite serious procedural violations, which we talked about earlier. DMV's disregard of the rules and the unanticipated introduction of purported expert testimony far afield from DMV's disclosures and into improper areas was unfair to Tesla because it deprived Tesla of notice of the substance of Smith's testimony and forced Tesla to confront Smith's testimony without adequate opportunity to prepare to rebut it. The ALJ also flouted the proper role of experts, allowing Smith to testify to the ultimate legal conclusion in the case. Smith's testimony that was beyond his area of expertise and went to the ultimate legal conclusion in the case was wholly inappropriate for the ALJ to consider, let alone for DMV and the ALJ to rely upon in their findings. Smith's testimony was the only evidence, outside of the evidence the ALJ herself describes as hearsay, that the order found persuasive in support of its holding for both of the terms Autopilot and FSD. That was it. That's all they have. Finally, the ALJ issued her recommendation to DMV. DMV kept that recommendation secret for approximately 30 days without alerting Tesla or giving it a chance to respond. Indeed, DMV refused to speak with Tesla despite numerous requests for open communications. The unfairness of the proceedings below constitutes prejudicial abuse of discretion that requires the setting aside DMV's order. So they talk a little more about the declaratory relief they want. And on page 44, they say, the procedures below, when viewed as a whole, violated Tesla's due process rights. DMV investigated Tesla's actions and drafted reports before shifting roles and, for all intents and purposes, serving as prosecutor by filing charges against Tesla and serving as the complainant throughout the proceedings. After that, DMV again shifted roles and donned the cloak of final decision maker. Here, that blending of roles renders the DMV decision makers intolerably biased and falls far short of the neutral decision maker required by both the federal and state constitution, because Tesla was subjected to a process that is structurally riddled with unfairness and repeated unfair procedural errors. The cumulative effect of these errors, coupled with the blending of DMV's roles, constitutes a violation of Tesla's due process rights. And they go over again a lot of the stuff that we've already discussed. Page 47, we're near the end. Finally, the ALJ released a recommendation confidentially to DMV that Tesla had no chance to see, and in fact found out about from the press. You gotta wait for the news. Imagine that. You're on trial for something, you're waiting for the jury to come back, you hear nothing, your lawyer hears nothing, then all of a sudden you turn on the news and you're found guilty. It's like, what? In short, DMV's role as investigator and decision maker, combined with a litany of procedural violations, violates fundamental due process norms, which requires a neutral and detached judge in the first instance. And they are asking for the court to issue a preemptory writ of administrative mandate to set aside the determination, issue a declaratory judgment that the order is unconstitutional, issue a declaratory judgment that the vehicle false advertising statute or any other statute DMV contends would permit it to ignore the context in which the labels FSD or Autopilot appear is unconstitutional as applied here, issue a declaratory judgment that the partial driving automation feature statute is facially unconstitutional, issue a declaratory judgment that the order is unconstitutional under the due process clause, costs of the suit and reasonable attorney's fees, remand the case for hearing, and other equitable and legal relief such as the court may deem just and proper. Imagine if this were your company. Imagine if this was you just doing business as yourself. Oh, you're misleading claims. Okay, who did I mislead? Well, we don't actually have anyone. Well, where are the statements? Right there. Well, those statements aren't misleading. Well, we got a guy who says that people are stupid and might think they are. Okay, does he have any expertise? No. Is he a linguist? No. Is he a marketing guy? No. And then you find out that the person who is the complainant is also the prosecutor and is also the final decision maker. Kafka never predicted anything like that. This is crazy, so hopefully the California courts will see this for what it is and kick it out. But do you see what I mean? This is crazy. This isn't about California having issues with the term autopilot or whatever. This is about California insisting that they must be misleading no matter what, starting with the conclusion and arguing from it, all in order to bully Tesla. And all of this just seems to enforce what I had concluded earlier in my other videos on it, that renaming Autopilot will not solve anything. Renaming FSD will not solve anything. They'll just do it with a new name. Because anything you could say about the new names, whatever new name they put in, they could plop right in. They'd do a search and replace for it and make this exact same judgment with this exact same so-called evidence. And it will be just as bogus. So hopefully cooler heads prevailed. You know I'll keep you updated, so please, comments for the comment god, shares for the share throne. Please hit like, subscribe, and the bell, and of course, donate to unambiguously.tv to keep me doing this. Through thick and thin, through tough times and good, whether one-time donations or regular support. So thank you so very much for watching. Until next time, stay strong and be free.